In this lecture series, I am discussing the topic of bringing on record legal representatives of any deceased party. I have so far delivered 4 lectures on this topic, and there are 4 video lectures on this topic. First lecture is relating to introduction of all legal provisions under the Civil Procedure Code relating to this topic of bringing legal representative on record. Second topic is especially relating to limitation period provided under Article 120 and Article 121 relating to bringing legal representative of deceased defendant on record. Third lecture is relating to limitation period provided under Article 137 of the Limitation Act. Fourth lecture is relating to, it deals with the situation where the suit abates only against the deceased party and suit do not abate as a whole. And this is the fifth part of this lecture. In this lecture, the topic is bringing legal representatives in partition suit. Bringing legal representative under Order 1 Rule 10 of Civil Procedure Code. So, partition suit and Order 1 Rule 10 of Civil Procedure Code. I am discussing this topic with the help of reported judgment of one reported judgment of Karnataka High Court. The citation of this judgment is year 1999, All India High Court, page 1202. The facts, the parties before this this judgment is given in the civil revision petition, and parties before the Karnataka High Court in this civil revision petition are one Rojappa versus Muthappa. Rojappa is the applicant in this civil revision petition before the High Court. Muthappa is the opponent. The facts in this case is that one lady whose name is Gangu, she filed a suit before the trial court in the year 1983. Gangu filed one suit for partition and separate possession of the suit property. She filed a suit for partition and separate possession of suit property against her brother. In that suit, in that partition suit filed by that Gangu, so in this case, plaintiff is a sister of defendant, or defendants are brother of the plaintiff, other way. So this is suit between sister and brother. In this suit, trial court passed the preliminary decree. So generally in case of partition suit, court initially passed the preliminary decree. By passing the preliminary decree, what the court does? Court actually ascertain and fix the share of the plaintiff and as well as share of the defendant. But because in case of partition suit, shares of each party get ascertained and determined and fixed, then it may be a party may be a plaintiff or party may be a defendant. So in case of partition suit, initially court, after considering the legal law applicable to the parties and case, substantive law, court determined the shares in the joint property of each of the parties to that suit. And after passing of the preliminary decree, what remains for the total disposal of this partition suit? That actual division of the property by metes and bound, and giving exclusive and separate possession of separated part of that property to each co-sharer, each sharer. And after doing that, should get disposed of by final decree. So in this case, the court has passed the preliminary decree, and being agreed by that preliminary decree, the first defendant, who is the brother of that plaintiff, preferred appeal before the district judge. The first defendant preferred appeal before the district judge because it may be his contention that whatever extent of share is allotted to that plaintiff sister, that may be incorrect. It may be a contention of that defendant. Therefore, that defendant brother preferred appeal against that preliminary decree passed by the trial court, preferred appeal before the district judge. That appeal was numbered as regular appeal number 165 of year 89. When that appeal was pending before the appellate court, that plaintiff died on 26/7/1993. So in this appeal, that plaintiff is now respondent. That plaintiff Gangu, she is now respondent, and her brother is appellant in that appeal. So that plaintiff Gangu, who is a respondent in this appeal before the district judge, she died on 26/7/1993 while that appeal was pending before the appellate court. Thereafter, the first defendant, who is appellant in this appeal, in that appeal before the district judge, he filed interim application, but under Order 1, Rule 10 of the Civil Procedure Code, to bring the legal representative of the deceased plaintiff, deceased Gangu, as respondents in this appeal, in that appeal before the district judge, in her place. So, the respondent, that appellant in that appeal before the district judge, who is a defendant in the suit, that brother, he made an application to bring the legal representative of the deceased plaintiff Gangu, but he made application under Order 1, Rule 10 of the Civil Procedure Code. But that application was opposed by those legal representatives of that respondent Gangu, deceased Gangu. That application was opposed by the legal representative of that deceased Gangu, and therefore that application, interim application to bring the legal representative of deceased Gangu, that application was rejected by the district judge. That application was rejected by the district judge. Why that district judge has rejected that application? That interim application to bring legal representative of deceased plaintiff Gangu on record. This application was filed by the appellant defendant before the district judge. That application was rejected by the district judge. District judge, before this district court, that advocate who is appearing on behalf of the legal representatives of that deceased Gangu, who was the respondent in that appeal and plaintiff in suit, that advocate on behalf of the respondent, he submitted that the law of limitation prohibits the appellant to bring the legal representative of deceased plaintiff on record beyond 90 days from the date of death. So what is the contention of that advocate on behalf of the respondent? Law of limitation prohibits the appellant to bring the legal representative of deceased plaintiff, that is respondent here, on record beyond 90 days from the date of death. That advocate further suggests that an application which has been filed actually under Order 1, Rule 10 of the Civil Procedure Code, that application is filed to get over the prohibition, under Order 22, Rule 4. Therefore, it was submitted by the advocate on behalf of the respondent that what he cannot do under Order 22, it cannot be permitted to be done under Order 1, Rule 10 of Civil Procedure Code. So this argument is accepted by the district judge for rejecting that interim application filed by the respondent. So we know that for bringing the legal heirs of the defendant, of the deceased defendant, the limitation period is provided in this Limitation Act under Article 120. The limitation period is provided under Article 120, 90 days. And period of 90 days is to be counted from the date of the death of that deceased party. Date of the death of that deceased party. So it is mandatory for the plaintiff, or in case of appeal, it is mandatory for the appellant to make such an application to bring the legal representative of the deceased respondent on record within the limitation period of 90 days from the date of the death of that deceased respondent. But in this case, that application has not been made within that period of 90 days. And even that application has not been made under the provision of Order 22 Rule 4 of the Civil Procedure Code, but that application has been made under the provision of Order 1 of Rule 10 of Civil Procedure Code. So it is the contention of the advocate on behalf of the respondent that appellant has purposefully made an application under the provision of Order 1 Rule 10 of Civil Procedure Code to get over the prohibition which is contained in Order 22 Rule 4 of the Civil Procedure Code. So he contended that what one cannot do under Order 22, then it cannot be permitted to be done under Order 1 Rule 10 of Civil Procedure Code. And this argument is very well accepted by the district judge for rejecting that application. Further facts in this case which also provide grounds for rejection of that application is that when that application has been made, while that appeal was pending, that first respondent plaintiff, that is Gangu, died on 26/7/1993. She died on 26/7/1993. Then her respondent before her advocate, who has appeared before the district judge, he reported this fact of death of his client, that is the respondent. He reported this fact of death of that respondent before the court on 28th June 1995. Means after lapse of 2 years period, that advocate who was appearing on behalf of the respondent before the district judge, he reported this fact of death of that respondent after the 2 years before the district judge. And therefore, thereafter, the appellant has filed that interim application to bring legal representative of deceased respondent on record. But this application is made after the lapse of period of 2 years from the date of death of that respondent. Nevertheless, these are the admitted facts in this case that Gangu, who was now deceased respondent, she is the sister of appellant. She is the sister of appellant who was the defendant in suit. This fact is not disputed. They are residing in close neighborhood. Therefore, under such circumstances, it is the observation of the district judge that under such circumstances, it goes without saying that appellant brother was very well aware of the death of her sister Gangu. He was aware about the death of her sister Gangu from the date of her death, which occurred on 26/7/1993. Then also, he made an application after the lapse of 2 years from that date for bringing the legal representative on record of that deceased sister. Therefore, the district judge dismissed that application, interim application, and consequently, district judge also dismissed the appeal as abated. Against this order of district judge, This matter came before the High Court in revision petition, and that revision petition is filed by that Rojappa, who was the appellant before the district judge and defendant in the suit. That is the brother of that deceased Gangu. So he filed this present revision petition before the Karnataka High Court. Now, what is the observation of the Karnataka High Court regarding this case? It is held by the High Court that Order 1, Rule 10 of Civil Procedure Code gives an independent right to the parties themselves to come on record. Order 1, Rule 10 gives an independent right to the parties themselves to come on record, but under Order 22, Rule 9, under Order 22, Rule 9 Civil Procedure Code, it is for the parties. Which parties? In case of suit, plaintiff; in case of appeal, appellant. And under Order 22, Rule 9 C.P.C, it is for the parties to bring on record the legal representative of deceased party. And that application under Order 22, Rule 9 Civil Procedure Code, that application is also governed under Section 5 of the Limitation Act, and the discretion is given to the court to condone the delay if there is a delay, to condone the delay and to set aside the abatement order if there is an abatement. On the other hand, in an application filed under Order 1, Rule 10 of Civil Procedure Code, the question of limitation period does not arise, more so in a case of suit for partition. So, see, firstly, in case of death of defendant in case of suit, or in case of death of respondent in case of appeal, it is a duty of plaintiff in case of suit, and it is a duty of appellant in case of appeal to make an application under Order 22, Rule 4 to bring the legal representative of the deceased party on record. For that purpose, the limitation period is provided under Article 120, that is a period of 90 days from the date of death of the deceased party. Suppose within that period of 90 days, if such application has not been made, then after the expiry of that period of 90 days, should get abated automatically. It is the effect of law. So, if in case that application has not been made under Order 22, Rule 4 of the Civil Procedure Code within that period of 90 days, then suit get abated. There is abatement of suit. Then, once the suit get abated, then in that case, further, one more chance is given to the plaintiff or the appellant, as the case may be, to make an application to set aside the abatement order, and for that period the limitation period is provided under Article 121 of the Limitation Act. That period is 60 days, which is to be counted from the date of abatement. And what is the date of abatement? That is date of abatement is after the expiry of that initial period of 90 days. So after the day after expiry of that initial period of 90 days, it is a date of abatement, and from that date of abatement, limitation period of 60 days is provided to make an application to set aside an abatement. That application is to be made under Order 22, Rule 9. Order 22, Rule 9, which says, Order 22, Rule 9, and its sub-rule says that plaintiff, or as the case may be appellant, may apply for obtaining an order from the court to set aside the abatement or dismissal, and if it is proved that he was prevented by insufficient cause from continuing the proceeding, then court shall set aside the abatement or dismissal upon such term as to cost or otherwise, and in such case the provision of Section 5 of the Limitation Act shall apply to the application made under this Rule 9. So application under Section 5 of the Limitation Act is to be made to condone the delay if there is a delay for making such an application. Thus, in case of application made under Order 22, Rule 9 to set aside the abatement, the issue of limitation period arises. But in case of application which is made under Order 1, Rule 10 of Civil Procedure Code, the question of limitation does not arise. The question of limitation does not arise, and especially in case of partition suit, there is no question of limitation. So it is observed by the High Court. Why it is so? Because see the provision of Order 1, Rule 10. the question of limitation. Order 1, Rule 10 and its sub-rule says the court may at any stage of the proceeding, either upon or without the application of either party, the court may order that the name of any person who ought to have been joined, whether as a plaintiff or defendant, or the name of any such person whose presence before the court may be necessary in order to enable the court effectually and completely to adjudicate upon, and settle all questions involved in the suit, then in such case, the name of any such person whose presence before the court is necessary be added as a party in that matter. In fact, this Order 1, Rule 10, its sub-rule 2, it talks about the power of the court. So court may at any stage of the proceeding. So it was held by the High Court. In this revision petition that when an application is made for bringing the legal representative on record of any deceased party under Order 1, Rule 10 of the C.P.C, the question of limitation does not arise, more so in a suit for partition. Why the special treatment is given to the partition suit? This power under Order 1, Rule 10 of the C.P.C is very extensive power of the court, and there is no limitation or restriction. Curtailing or restricting the power of the court to add the parties in the matter under Order 1, Rule 10 of the Code of Civil Procedure Code. And why this special treatment is especially means why the parties are allowed to be added under Order 1, Rule 10 of the C.P.C in case of partition suit. The reason is that the defendant in case of suit or respondent in case of appeal, the defendant or his legal representatives in a partition suit is equally interested as the plaintiff is interested in having the properties in suit partition. So defendant or his legal representative in partition suit is equally interested as the plaintiff is interested in having the properties in suit partition. The position of parties in a partition suit is different from the position of the parties in ordinary suit. In a partition suit, every party is in the position of the plaintiff, and the court in such cases should, in exercise of the power under Order 1, Rule 10, add the legal representative of deceased party even after the suit is abated. So in a partition suit, the court should, in exercise of the power under Order 1, Rule 10, add the legal representative of deceased party even after the suit is abated, because the legal representative of the deceased defendant or the respondent, as the case may be, legal representative of deceased defendant are co-sharers, and as such they are necessary parties in a partition suit. So while giving this judgment by this Karnataka High Court in this revision petition, they have referred one earlier judgment, old judgment of one Bombay High Court in support of their conclusion. So it was held that in that reported old Bombay High Court case, it was reported by that Bombay High Court that it is obvious that in a partition suit all parties should be before the court. That in that case also, before the Bombay High Court, in that case also, the suit has there was also a preliminary decree in that suit, and therefore the Bombay High Court in that case observed that the suit has actually reached the stage of commission to divide the property, and the applicant is a sharer. Applicant that before that Bombay High Court. Under Order 1, Rule 10 of the Civil Procedure Code, the court may, at any stage of the proceeding, order that name of any person whose presence may be necessary in order to enable the court effectually and completely to adjudicate upon and settle all the question involved in the suit, name of such person be added. So it is also held by in very old case in case of reported case of the year 1911, reported a case of this Bombay High Court. So in this present matter, this Karnataka High Court also held that in this present matter, it is also observed by this Karnataka High Court that this suit is also for partition. The first defendant who suffered a preliminary decree preferred an appeal, and the plaintiff was arrayed as the first respondent. The plaintiff, that is the respondent, died, and in her place her children were to be brought on record as legal representative. But since the application under Order 22 Rule 9 was barred by time, the appellant filed this application under Order 1 Rule 10 of C.P.C. So in this case, it is a fact that limitation period provided under Article 121 to make an application to set aside abatement, that application is to be made under Order 22 Rule 9. Limitation period is 60 days from the date of abatement. In this case, this period was already expired because the application has been made after the lapse of 2 years from the death of that respondent. Therefore, since the application under Order 22 Rule 9 was barred by the time the appellant filed this application under Order 1 Rule 10 of Civil Procedure Code, therefore, the finding of the district court, that is First Appellate Court, therefore the finding of the court below that the appeal abates, and the application is filed under Order 1 Rule 10 C.P.C. only to circumvent the provisions of Order 22 Rule 4 cannot be accepted. So it was the conclusion of that district court that appellant has made this application under Order 1 Rule 10 of the C.P.C. only to circumvent the provision of Order 22 Rule 4. This conclusion of district judge is not accepted by the High Court here, and the finding of that district judge that the appeal abates, that finding is also not accepted by the High Court now. Therefore, ultimately, High Court is of the view that this present petition deserves to be allowed. This present petition means it is prepared by that appellant brother of deceased Gangu respondent. Therefore, this revision petition is allowed, that impeach order passed on interim application by the district judge is set aside, and that regular appeal which was dismissed as abated by the district judge, that regular appeal against the preliminary decree passed by the trial court, that regular appeal is restored on file, directing the district court below to permit the appellants to amend the appeal memo for bringing the legal representative of the deceased respondent. Accordingly, this petition is allowed. So I stop here, but I will consider some another topic relating to this main topic in my next video part of the lecture. Thank you.